in the past. In recent past, in the last decade, we've seen the growth of administrative law as a subject, as a legal point, in the legal point of view. Now, although administrative law existed in the past too, in the current century, with the increase in the role played by the government, this has resulted in the increase in the administrative law. During the olden times, the concept of laissez-faire or police state used to exist. These were times when the role of the government was limited to only defense, maintaining law and order, and collecting revenue, etc. The state per se or the government did not interfere in the day-to-day affairs of an individual. This now coming to the word laissez-faire. Now laissez-faire was a concept which existed in the English law largely. There the government never interfered in the day-to-day affairs of a person, say manufacturing or distribution of essential commodities, etc. A person could take birth and die without even having a single encounter with the government. Now, police state is in the same lines. In a concept of police state, the only role played by the state is defense and maintaining the sovereignty or sovereign affairs of the government. Today, the state has a much higher role than just of providing security. Today, the concept of welfare state has come into picture, and the functions and responsibilities of a state has since increased and inevitably increased the role of administrative law. Now, what is we'll talk about what welfare state is. What do you mean by a welfare state? Today, the state is not just a police state like we mentioned, or we don't have the concept of laissez-faire. And it has grown to become a progressive and a democratic state. The state strives to ensure welfare of the people and tries to bring in the common people's interest into picture. It exercises control over areas such as social security, like manufacturing, production and distribution of essential commodities, striving to bring in equality among men and women, equal work for equal play. In India, these are enshrined under the directive principles of state policy. The Constitution of India, under the Part 4, provides for directive principles of state policy, and these are mainly the roles or duties of the government towards the citizens of India. Now, these are the welfare schemes. Largely, what the welfare state defines is through the directive principles of state policy in India. So India has enshrined under the directive principles depicted the state promotes welfare of the people. In short, the modern state takes care, there is a phrase that says the modern state takes care of a citizen from the cradle to the grave. So from the moment a person is born, his right to a healthy, thus in India, these are enshrined under the directive principles of state policy, that is Part 4 of the Constitution of India, which are the welfare schemes, which are the duties of the government towards the citizens of India, and these are the welfare schemes that has replaced the police state or the laissez-faire kind of a situation, and now we've brought up administrative law into picture. Now these are the reasons why we have administrative laws in picture, because with the increase of role played by the government or the functions of the government, the state cannot function everything or have detailed knowledge about everything. So we have delegated legislation coming into play because of this, and we have other agencies or other administrative bodies who takes care of these welfare schemes how they are to be implemented or promoted, etc. Now, in short, the modern state that we have right now takes care of a citizen from the cradle to the grave. Now, this is a very interesting phrase, from cradle to the grave, because from cradle means from the birth of a person, his right to health, a proper health facility given, his right to education, his right to free education, his right to be treated equally. From that onwards till the grave, when a person dies, his right to his will being executed, or his right to be buried or cremated as per his wishes. These are all have a implication of welfare under it. So the government or the state plays an important role in executing such welfare schemes. Moving ahead, let's discuss the object of administrative law. Now, to enable the welfare functions of the state, it is important that the powers and privileges be vested in the executive organ of the state. Executive organ of the state who executes the legislation or the various schemes that we have for the citizens of India. Now, needless to say, power corrupts, and absolute power corrupts absolutely. We have seen this in existence that we have, if a person has a power to do something or a higher authority over something, he can use it for his own interests, personal interests, or possibly in an illegal way or a not so correct way. So power inevitably corrupts. Now, whenever there is discretionary power vested, there is always a strong possibility of this inevitable or illegal act coming into picture. To ensure this, we have to ensure this that such power does not corrupt, we have to bring into picture some kind of control or some kind of restriction to these executive bodies. Now, this can be achieved through two basic or two broad means. First is political control through legislature, and second is the legal control through the judiciary. Now, we'll be discussing this in detail because how we have a political control over the executive and we have a legal control over the executive. We have remedies which a person can exercise against some kind of illegal activity or inevitable corruption of power against him. Now, administrative law strives to provide remedies against such misuse, non-use, and the abuse of such administrative authorities. Today, the citizens of India have various remedies available, such as right to information, public interest litigation, and judicial activism. Now, these are, let's say, the pillars or the power pillars of the judiciary through which a citizen can enforce his right. When any kind of illegal activity or an abuse happens to a citizen, the citizen has a right to say, go to the right to information, under the right to information provision, go and ask or demand for what the paper is. Or we can have any public document revealed to the person or the citizen of India, whoever approaches the government with such schemes. We have public interest litigation where any person aggrieved because of any authority can go to the courts of law and demands justice, and such is judicial activism, where the courts themselves can take up such schemes or such abuse of such schemes. The primary purpose of administrative law is to keep the governmental authorities within the bounds, so the interest of the citizen do not suffer. The primary purpose of administrative law is to keep the governmental authorities within their bounds so that the interest of the citizens do not suffer. The administrative law governs both the internal functioning of the government as well as the external manifestation of it. It does not restrict itself to just the law-making powers. It also takes care about how these laws are implemented and whether these laws are correctly implemented as per the need of the hour. Now, as we've already mentioned, the sole purpose or the major object behind administrative law is to keep these authorities within their bounds so that they don't corrupt and they don't act illegally or misuse the power given to them. Now, administrative law also ensures that the duties of public authorities are performed well so as to provide justice to the citizens. We know that a lot of public authorities are given a lot of duties. Now, as we've discussed earlier, under the directive principles of state policy, we have duties given to the government to provide free education, to provide equal pay for equal work, to provide a healthy and a clean sanitation facility or environment. Now, these are enshrined these are given by the legislation. Now, what the administrative law does is makes sure that these duties are performed by such public authorities. Now, let's take a small example. That is repayment of illegally levied customs duty. Now, we know that there is customs duty which has been levied if you import some kind of stuff into India, products or say stuff. So there is a custom duty that is levied. Now, this is under the customs officer. if there is any person who has been illegally or wrongfully levied some kind of custom duty, the administrative authorities have the right to rectify it and reimburse such customs duty to the person who was illegally or wrongfully levied such amount. This is one kind of example of how administrative law can play a major role in a single person's life. Thus, administrative law deals with the negative as well as the positive administration and maladministration. So, they have a right to do something and they have a right to bar somebody from doing something. This is the positive as well as negative impact or side of administrative law. So, the main object of administrative law, if we conclude, is to unravel the way in which these administrative authorities could be kept within their limits, so as the discretionary powers may not be turned into arbitrary powers. There are powers given to the state or given to the governmental bodies now to keep these bodies under check, under control, so that they don't misuse their power and become an arbitrary state of affairs. That is why administrative law is important, and that is why administrative law has come into picture in the first place. Now moving ahead, let's discuss about the growth of administrative law, the reasons for growth of administrative law, or why do we have administrative law in the first place. So there are a lot of factors that have contributed in the empowerment or enlargement of administrative law. We have broadly 9 categories or 9 reasons why. Let's go to them into one by one. First is the radical change in the role played by the state. As we've already discussed, earlier we used to have a laissez-faire state of affairs or the police state. Today we have a welfare state. So obviously the burden or the roles and functionings of the government has increased with the welfare state coming into picture. And the concept of from cradle to the grave, like we've already discussed, that has come into play, and with the increasing roles of the government, the responsibilities have increased, the functionings have increased, and so we have administrative law coming into play to divide such works into those peoples who are capable of doing or capable of executing such welfare schemes provided by the government. Secondly, the inadequacy of the judiciary. Now, the judiciary is inadequate to settle disputes of all kinds. Of course, we know that the judicial system hires experts in the field when there is a kind of area where the judges are not familiar with. But what if we have a system where those experts are the judges? Now, this is why administrative law has come into play, because the judicial system is lengthy, it is time consuming, it is slow, it is expensive, and it has a lot of technicalities, so it is very complex. So we have the tribunalization coming into picture. We have administrative tribunals being introduced, where the experts in the field will be coming and adjudicating the matter in hand. For example, let's say there is an industrial matter in hand. There's a dispute between an employer and an employee, a group of employees, and the employees have declared. Now, the second reason for the growth of administrative law is the inadequacy of judiciary. Now, the judiciary is inadequate to settle disputes of all kinds. We have various areas where a dispute may arise. Now, we all know that the judiciary hires experts in the field when a particular matter is in hand. But what if we have a system where that expert itself is the judge in the matter or is adjudicating the matter? That is how the picture of tribunalization has come into play. We all know that the judicial system or a litigation is expensive, is lengthy, is complex, and is a time consuming matter. So judicial process, since with the slow process or the complexity of judicial system, we all know that tribunalization has eased out the situation. We have administrative tribunals being established in various areas who would adjudicate a particular matter in hand. Now, for example, if there is an industrial dispute or an industrial matter in hand, where an employer and a group of employees have a dispute amongst them, and the employees have called out a lockout. Now, in such situation, we can't expect them to go to a court of law and have a full-fledged litigation going on, because that is expensive and that is time consuming. By the time we have a judgment in that matter, a lot of time would have passed, and it would have resulted in a huge loss for the employer as well as for the country in general. So we have industrial tribunals being placed where such matters would go to in the hands of such experts in the field who can adjudicate the matter well. Thirdly, we have inadequacy of the legislature. The law-making process is slow and inadequate for matters which require detailed knowledge in the area. We all know that we have the parliament in session, and if a law has been made and a law has to be declared for a particular area which is a very intricate or very small or very niche category, we know that everybody in the parliament does not have a detailed knowledge about that. What if those laws are, what if we have a system where the laws of such area or such matter in hand is being made by people who are experts in that field? That is how delegated legislation have come into play. The law-making power has been delegated to such experts who have detailed or intricate knowledge in the matter. So it is impossible for the legislature to lay down detailed regulation for every matter in hand. They can have a broad regulation made, they can have a parent act being made, but the rules and regulations of such act should be made or would be made by experts. Now thus delegated legislation of the rule making power has come into play, and that is how the administrative law is dealt with or has come into picture in this matter. Now next point, or the next reason for the growth of administrative tribunal, is the scope of experimentation. Unlike in the legislature, where the law has to be continued until the next session of the parliament, under the administrative laws or by the administrative authorities, a law can be implemented, tried for some time, and if the law is seen or is known to be defective for some reason, it can be changed or modified as per the need of the hour, which is not the situation in the legislature, or if the parliament is making a full-fledged law on such topic. Now the next point is preventive actions. Unlike the judiciary, where the court can only take up matters if some person or some party who has a conflicting interest in such matter comes to the court, here the administrative authorities can take up the matters by themselves. In a court of law, a person who has been aggrieved of some issue or his rights have been infringed comes to the court and files a complaint, or a litigation starts. Otherwise, though we have judicial activism and areas such like that, but we know that the judiciary does not per se come and take up actions for every small matters in the lives of a citizen. In such cases, the administrative authorities comes into picture, who know that if a particular law is not being implemented properly, they can come into play and they can take up such actions to rectify such mistakes. Now this helps in avoiding the extensive time consuming litigation process. Like we've already discussed, that a litigation once started goes on for a long time, it is time consuming, it is costly affairs. So this can be curbed, or this can be reduced by administrative authorities. I can give you a small example on this, such as licensing or health standards, fixing health standards, etc. We know that the administrative authorities have the right to give out licenses to, say, a particular restaurant to be begun, and they have a health standard being fixed for a hospital, which if the administrative authority feels that the health standards which has to be maintained is not being maintained by that particular healthcare facility, they can take up actions on their own. They don't have to wait for the courts to come into picture, so they have the right to take preventive actions apart from their right to make such legislation or rules and regulations. So that is how administrative law those are the reasons why administrative laws have come into picture. Now next is administrative authorities can avoid technicalities. Now this is something we've already discussed. The administrative law focuses on the functional aspects rather than the technical and legislative aspects. The codes are formal, rigid and complex. Like we've already discussed, the courts follow a particular set of procedure which cannot be neglected. Under the administrative laws, these procedures or the law of evidence or the CPC, the Civil Procedure Code, need not be followed. Thus, this is how, or this is why the time consuming factor has been reduced largely in the administrative law. This is why the people prefer going to administrative tribunals, or even if not people preferring, this is how administrative laws or administrative authorities would ease a particular problem rather than going to a litigation process which has to, where law of evidence and law of civil procedure code has to be followed. So this will obviously result in a speedy approach or speedy redressal of a particular problem. Coming to the next point, we have better enforcement. Administrative authorities can take up enforcement measures over and above their preventive regulations in order to maintain social order. Coming to the next reason for the growth of administrative law, we have better enforcement. The administrative authorities can take up enforcement measures over and above their preventive regulations in order to maintain the social order. Now we know that administrative authorities have the right to make preventive regulations. So, for example, such as if a particular standard has not been maintained, we can revoke your license. But if the administrative authority does not have the right to actually go ahead and revoke that license, there is no point in bringing out the preventive regulation in the first place. So here what we are seeing is that the administrative authority has such right to actually go ahead and cancel such license of the person if a particular standard has not been maintained. So basically this rounds up to the fact that the enforcement measure or the right to enforce the preventive measures is also been given to the administrative tribunals. It is not delegated, or it is not done by a separate body. Like in the actual or the broader picture, where if we see in India, we have the legislature, we have the executive, we have the judiciary. If the executive is not properly executing, the judiciary comes into picture to enforce such rights. The next reason for the growth of administrative law is better enforcement. Now, the administrative authorities can take up enforcement measures over and above their preventive regulations in order to maintain social order. Now, we know that if a body does not have the right to enforce a particular preventive measure, there is no point in bringing out the body in the first place. So, if we take an example, we have, say, a standard to be maintained by a particular organization, and if such standard is not maintained, we would revoke their license. That is the preventive regulation by the administrative authority that is in picture. Now, if that administrative authority does not have the right or the power to actually go down and cancel such license of the person, there is no point in bringing out the preventive regulation in the first place. We can't just have preventive regulations in place and not be able to actually implement such preventive measures. Now, this is actually the case in the case of administrative authorities. They have the power to go down and enforce the measures which they have provided under the preventive regulations. Now, for example, we can take destructions of contaminated food during festivals. Now, we all know that during festivals such as Diwali, we have a lot of adulterated foods taking rounds in the society. We have a lot of sweet shops who adulterate food or contaminate food and sell it for cheaper rates. Now, if the government, the administrative authorities have the right to maintain such standard, and they have the right to go ahead, and if such standard is not being maintained, they have the right to go ahead and destroy such food which are contaminated. So they have the power to go ahead and do that, which is not the same case in the larger picture. If you see, the legislature, the executive and the judiciary have bifurcated their roles. We have the separation of powers, and one body performs only their function. Here in the administrative body, the administrative body performs all of these functions in a smaller scale. They have the right to make the regulations or rules, they enforce or implement them, and they also take up remedial actions in case of non-implementations. So these are not generally available through the normal court of law, because if there is some contaminated food taking rounds in the society and we go to the legislation, by the time we have a judgment for that matter, that entire season must have already finished in another year's festivals would have come into picture already. So the speedy redressal as well as the enforceability or the enforceable measures that can be taken is being provided under administrative authorities. Further, we have combination of functions and policy formation. Like we've already discussed, the administrative body is like an executive body which is exercising quasi-legislative and quasi-judicial functions. They have the right to form, they have the right to execute, and they have the right to implement or take up policies where these policies are not adequately implemented, take up actions for in such cases. Now this helps in framing better policies and gives an all-round solution to a given problem. If one body is taking care of a particular area, say industrial disputes, if there is one body who sets the rules and regulations, the intricate rules and regulations which comes into play for the day-to-day affairs of the industrial areas. If there is one body who makes such rules, who implements or gives preventive measures and also executes the penalty or the penal provisions of it, we know that such body gives an all-round protection to the matter in hand. So that is the next point of why administrative laws have grown to such a wide aspect. Now we have the last point, that is implementation of policy. Policy formation and policy implementation are two very different aspects. This also we have already discussed. Now formulated authorities are in a better position to implement the policies formulated by them. If the administrative body has made formatted a particular policy, and that policy has been given to some other body who has to implement, who is given the duty of implementing such policy. Now we know that one body must have formatted the policy keeping in mind some aspects. We know that there are underlined implementations or underlined reasons why a particular rule is being made. If another body is given the implementation power of such rules, they may implement such regulations in a slightly different manner from the actual object of the regulation. We know that there can be a slight difference in the object of the regulations being changed. There's a possibility that the overall reason why such regulation is being made is being defaulted, or there is a small change in it. But if the same authority who has implemented the policy also executes the policy, we know that the reason behind making such policy is not deferred, or we know that the actual reason for making such implementation or making such policy will be taken forward and been implemented as per the need of the hour. Now these are 9 major reasons why we have administrative law widening so much in the country. We have seen in India in the last century, since the 20th century, the administrative laws have widened its aspects to a huge amount, to a very large extent. These are the 9 major reasons why this has happened. Now, with the exam point of view, reasons for growth of administrative law is one of the most important questions that can be asked for as a long answer. So amongst the 9, a student is expected to at least give 7 reasons why such, in the answer the student is expected to give at least 7 reasons for the growth of administrative law. That is all for today's topic, that is the introduction to administrative law. In the next class, we will be discussing the nature and scope of administrative law and the definitions of administrative law. Thank you.